The next case that is set for argument is State of Ohio versus Chelsie Keller. It's case number 18CA011304. Both parties are represented by counsel, so each side will have 15 minutes to present your arguments. There is a child involved in this case as well, so we use initials as opposed to names for children and victims. The appellant, of course, may reserve up to 5 minutes for rebuttal. I'm keeping track of the time, so if you let me know how much time, if any, you want to reserve, I'll try to let you know where you're at. We do use the front podium, by the way, and the arguments are recorded, so we ask that you remain at the podium and keep your voice up. Now, we have read the briefs, and we are prepared to proceed if you are.
Thank you, Your Honor, and may it please the court. Just for the record, I'd like to reserve 5 minutes for rebuttal.
5 minutes, all right. Thank you.
May I proceed?
Yes, please do.
May it please the court. This is an appeal of a jury trial. It's a 2-count jury trial where the defendant the appellant was found guilty. It's for child endangering and felonious assault. And the gist of this case is that essentially it was a circumstantial case. The state presented 3 witnesses. The defense presented 1. The state's witnesses were a social worker, a Miss Handler's mother-in-law, well, her ex-boyfriend's mother, but for purposes, her mother-in-law, and then a doctor. And the defense presented 1 person, that was the defendant's mother. On the day of this incident, the state comes in and they took custody of Chelsea's son. It goes back and forth. About an hour later, the caseworker gives that child to Chelsea's mother-in-law. Mother-in-law has the child at home for a few hours, sees a big bump on the back of the child's head. They transport the child to Amherst Hospital, eventually take him to Rainbow Babies in Cuyahoga. He has a host of issues, but the one issue here is that he has the bump on his back of his head is actually a skull fracture. That is the basis for the felonious assault and child endangering. Assignment of error number 1, it goes on to Criminal Rule 16K, talking about an expert report. So Dr. McDaniels, who is the doctor who testifies to this, she is a nurse that specializes at Rainbows and basically working with agencies to say, is it fine for a child to go home? She was not a traditional nurse or the surgeons or the attending physician that was dealing with the victim seeking. What happened is the surgeon refers the case over to her because he's a mandatory reporter. He knows that there's children's service issues. She looks at it and she basically, she puts in a 1-line finding that the injuries were intentional.
Did she examine the child or treat the child in any way?
Examined and interviewed the mother-in-law and one of the...
I'm talking about the child itself.
I believe so, yes. Because this all happened before he was released from Rainbow. They had to go to this doctor to get released, and she does talk about her different observations of some of the bruises in the cuts. Because she comes finding she can't date a bruise, she can't date certain scratches. But essentially what happens is the testimony that was proffered basically says that this was an intentional injury. And she goes into great depth on that injury. The medical reports was 1 line.
Well, there's a little more than 1 line, counsel. She makes reference to the child being non-ambulatory and that figuring into her opinion.
but that was expounded at trial. So you have her, she has a list of 5 or 6 injuries, and I listed in the brief, or not 5 or 6, 6, 7 or 8 injuries, where cannot dig the bruise, cannot do this. And now the skull fracture, she talks about it being, that it's intentional, but then she expounds on that at trial and explains, well, the child with this kind of injury, he cannot run around, he couldn't have inflicted on himself. And explains how that, to her as a doctor, indicates that it wasn't accidental. And that's a little bit where in medical records, she expands on those through her testimony.
I don't mean to throw you off track here, but I was having a hard time discerning from the briefs. Are those medical records a part of this trial record, or are they not?
No, they connected in. They did not have Ms. McDaniels wasn't privy to the rest of what happened, so she gets the case on referral from the surgeon, and that was actually one of the issues.
Let me save you some time for a minute.
Yes.
So they're not part of the trial. Were they preserved in any way? I guess the bottom line is I'm asking, do we have them to review?
I do not believe so.
Okay.
Because, and here's the reason why that was a big part of the evidentiary objections that were going on is one of them that the state was trying to proffer is medical statements made for medical diagnosis or treatment. The trial court actually turned around and said, well, it's a child that's nonverbal. These weren't statements that he would have made to physicians to be treated. And Ms. McDaniels could only testify about what she did. Because I was surprised by that, because as somebody who normally does a lot of trials, normally you can have that doctor that says, yeah, I've worked for university hospitals or the system for 10 years. I understand that these records are X, Y, Z, this would happen. And I was surprised that there wasn't a foundation that could be laid. But where this case really comes together on cumulative issues is you have 404 issues also. So the state presents 3 witnesses. Witness number 1 is the social worker. And the social worker has a litany of issues that everything was objected to by trial counsel, talking about the background of Ms. Heller. So Ms. Heller essentially had social workers under objection. How do you know Ms. Heller? Well, I dealt with when we took her other 3 kids away. I dealt with her when this child the victim was born. She had marijuana in her system. I brought officers with me because in the past she yelled at me and she threatened us. And subsequent to the child being taken away, she said, I'm going to blow this ditch out or after these first. And a lot of these issues were witness number 1, social worker talking about Chelsie. She's a piece of garbage. Essentially, they dealt with her for years. She's trash. Witness number 2 is a doctor that comes in and testifies that these injuries were essentially that they're not accidental, they're intentional. And then the grandmother comes in, the mother-in-law, I should say, she doesn't really testify to. She says she found a bomb on that. She doesn't really testify to. No one knew what happened in the house. But essentially, you had witness number 1 that was a lot of 404 stuff where how do you justify putting on the record that she had her other children taken away, that they've had problems with her, that their child was born with marijuana? That goes into other acts. It doesn't show the enumerated exceptions to Rule 404B. So you've already laid a foundation that this girl is essentially garbage. And the second witness, and that's an opinion. And what I'm arguing on that expert witness, the 16K, is that then the state brings a doctor in who says, yes, I went to Miami University, went to Yale, I went to Case Western Medical School. All I do is I analyze whether children are safe to go back to their home through Children and Family Services. And a lot of these injuries I can't tell, but this one, she's opining that it's intentional, it's not an accident. And that's the issue where if you have I stated at length Stacey Walls. And Stacey Walls was a case that I actually handled on retrial. But it was a similar issue in the 6th District where it was a delayed disclosure rape. The doctor was contracted through Children and Family Services in Lucas County. He gives like a once-over, he gives a report to CFS. He put in his original medical records in that case that kids didn't say anything happened. I find no evidence that there's been sexual abuse of these children. Fast forward a year and a half to trial, he's opining on delayed disclosure and how the kids were acting and their behavior, and that wasn't in his original medical reports. So he's opining, he's taking his specialized knowledge as a doctor and then laying it out to those facts. Likewise here, when you have this, when you have Ms. McDaniel testifying, and she's testifying to, well, the way the injuries were in the body, the fact that they were cumulative, non-ambulatory, that's all evidence from Ms. McDaniel as an expert. She's testifying as somebody who treats children, not as a layperson, not as me as a parent, not as the panel as a parent. She's testifying as, I'm educated at Yale, I'm a doctor, and based on her training and experience. But there isn't a report explaining, and she actually references that she's trained in, she works off the literature in the research studies.
Counsel, let me ask you.
Before you ask the question, I just want to let you know that you're at 4 minutes and 30 seconds total time left, so go ahead and answer the question.
On the Wallace case,
Yeah.
to the extent that that report said that there was no sexual abuse,
Mm-hmm.
that was an opinion, wasn't it?
Correct.
You had no problem with that part of it, correct? It was just when it went beyond that to
Well,
the
his
grooming
medical
and
record-
that sort of thing.
His medical opinion was that,
Well, what if the
No.
opinion was that there was sexual abuse? Would it be any different?
yeah, absolutely. The state has a burden. And when you have that person as an expert, and you have their CV, and you have their basis of where they're basing their opinion on that issue, such as there's when there's a lump on the back of the head, but you're saying that it's not accidental. Okay? When you have that basis of that opinion, then you can start attacking it, whether that is going on to Lexis and finding every opinion that doctors gave, whether it's pulling the CV, finding research studies, possibly hiring an expert. But the way this was presented was that this was a doctor that was testifying about an injury, not giving an opinion where that injury came from. And there's an excerpt in the brief and then also in the court where it goes, where the trial court asks, like, well, counsel, if we had a gunshot victim here, you wouldn't be objecting to the doctor saying he got shot. And trial counsel actually says, well, I mean, if he's trying to say it's self-inflicted or not self-inflicted, yeah, it would have an issue because that's an opinion from that doctor on how that injury occurred, not the facts of that injury. But where this comes together is that this is a circumstantial case. It's not a case where you have another 5 witnesses that are saying, yeah, Chelsie had this baby in his room, fell over, boom. This is a case where you don't have any eyewitnesses other than a defense witness who's like, yeah, I was in the next room, baby fell, heard a boom. You don't have anybody in that room, in that house that's saying this is what happened. So when you're taking this, criminal rule 16, it's not harmless. It has a major impact. When you do the 404B, major impact, because it's not that witness saying, yeah, I saw this. It's all circumstantial. So it's a trial by character assassination and then putting on somebody highly educated, giving an opinion. And that's where the conviction, that's where the assignments of error lie. I'd like to see, I don't know if I have any left.
You have 2 minutes and
All right.
8 seconds left. We'll give you that for rebuttal time.
Thank you.
15 minutes for the state.
Good morning again, judges. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. First, to answer what looks to be an odd procedural status, the medical records did not come in as evidence. I believe that was because the state failed to present any witnesses to testify regarding their authenticity
They were
or,
certified though.
I agree, Judge. That would go to their, it would be, yes.
Nonetheless,
They were, You know what, Judge, we shouldn't assume they were certified. I'm not positive that the record would reflect that. But from experience, yes, they almost certainly were certified, should at a minimum have been authenticated that way. But there was no stipulation pre-trial. Perhaps that was just a one-time oversight on the part of the prosecutor handling the case, but I don't believe that those records are going to be accessible to you. To answer another question, Dr. McDavid did testify that she examined and treated the juvenile victim here, CV, as we've been referring to her, which means she was the child's treating physician. And therefore, did she need to be qualified as an expert witness, or could she testify as a lay witness? We look to Evidence Rule 702, which allows for lay opinion testimony. While Appellant was making his presentation to you, I kind of got the sense that he was limiting opinion testimony to only expert witnesses. And that's just not accurate from Evidence Rule 702, which allows lay opinion testimony to include opinions and inferences when they are based, and actually this is Evidence Rule 701, when they're based on witnesses' perceptions and they help the trier of fact to understand testimony or determine a fact and issue. So lay opinion testimony results from the process of reasoning familiar in everyday life. For this particular doctor, her everyday life was examining child patients and drawing inferences and opinion conclusions from those examinations. The 12th district has actually held that treating physicians may be called as non-expert witnesses to testify about their patients' physical conditions. They're not experts retained anticipating litigation. That's Henry versus Richardson cited in the state's brief. The treating physician's opinions may be based on their personal observations and perceptions. Here, Dr. McDavid was a treating and examining doctor. She treated this child patient, which was very similar to a police officer testifying to the existence of a methamphetamine laboratory in State versus Williams, a case this district decided in 2011, and found that the police officer testified as a lay witness, didn't offer expert opinion, but he made personal observations from a trash pull and to items in the residence. And the significance of putting all those items together, while they may have been otherwise innocent items or everyday items, but when you put those items together, would give rise to the belief that the residence housed a methamphetamine laboratory. This district also allowed a crash-related, the personal observations from an officer who had investigated hundreds of crashes to testify about crash-related injuries to vehicle occupants based on his numerous personal observations in the past and to the significance of the injuries sustained to ultimately say who was seated where in the car, whether the person was a driver, whether the person was a passenger. That's the Klein case, again cited in the state's brief, the 2013 case. A doctor's testimony was also allowed regarding gangs in the 6th district in Swain in 2013. The appellant relies on Walls. Walls is really a wishy-washy decision. It's half-hearted in wanting to hold that 16K absolutely would keep out testimony if an expert report isn't given. I'll get to that in a second, but it's just good to keep in mind Swain because it's opposite what the court supposedly holds in the case in Walls. But Dr. McDavid, these officers testifying about gangs and crash-related injuries in methamphetamine labs, they're witnesses who have extensive firsthand, professional, and most importantly, I think, feet-on-the-ground experience. These aren't people who are being sought anticipating that some kind of litigation, criminal or civil, is going to ensue, but they're actually involved in the case. They become almost organically involved in the case and offer their observations and ultimately opinions derived from those observations. In Dr. McDavid's case, that these were non-accidental injuries and they were inflicted. The skull fracture was because of the other multiple injuries on a 7-month-old, as you point out, Judge Callahan, was non-ambulatory. It also goes to the mental state that the state was required to show with regard to the felony assault of knowingly and endangering child charge of recklessly, as Ms. Heller continually claimed and only claimed that the child fell off the bed. The state was required to show that this was then a non-accidental injury, which would go to the mental state.
Counsel, this case seems to be one, if you look at just the docket, that's all I have, where the defense actually filed at least one motion to compel regarding discovery.
Correct.
And I realize you weren't trial counsel, but do you have any idea what was specifically requested, and did the court rule on those motions?
I'm not positive. As I recall from the record, the state's view was, I think the assistant prosecutor who was litigating the case indicated to the trial court that everything that it could provide had been provided, that it complied with the rules of discovery.
Thank you.
Briefly, even if the expert report was required, there was no reversible discovery violation. Courts have the discretion to impose the least severe sanction possible. What Rule 16 seeks to do is give parties a chance to fully, fairly adjudicate the case, prevent unfair surprise. And Dr. McDavid testified consistent with what was in those records.
Of course, 16K said shall not.
Correct.
Shall not.
And it looks like it's a matter of first impression for this district, the 9th district, but the 5th district, the 11th district, the 3rd district, the 3rd district, the 6th district in Swain, different from Walls, the 12th and the 4th, and what I think probably better be described as dicta. They've considered the sanctions issue and say that despite what 16K says, that courts retain the discretion to deal with the violations in the least severe way possible. But again, the state doesn't even believe that an expert report was required, Judge, even if there was. Dr. McDavid testified consistent with those records. The defense had the chance to research these issues if it wanted to. It had been provided the information and discovery on October 25th of 2017. The trial started on March 12th of 2018. The defense counsel, even his first question to Dr. McDavid involved, I believe it was his first question basically, was a reference to some kind of treatise that of another doctor. So it's not like defense was caught off guard or surprised by anything here. Even asking about impact velocity and skull fracture types. I mean, that sounds like someone who was prepared and knew where he needed to go in a defense. Therefore, there was no prejudice, no willful violation, and the accused, in this case, Ms. Heller, it hasn't been demonstrated how she would have benefited in preparing a defense.
Let me jump back, because you've got me thinking about this. If there was a, say, violation, and a report was necessary, 16K says a violation shall result in no testimony, precluded from testifying. You're arguing other case law that says the court has discretion to use the least restrictive sanction, which in this case was or would have been what?
I think, based on what had been provided to the defense already, would have been a continuance. I don't know what more information the defense would have been able to glean from an official report that wasn't in those medical records that had been provided, which unfortunately also are not before you, so you're limited to whatever the record shows was in the medical records and argued there. But even the case cited to support the view that this Walls case, when you read the end of it, the 6th District says, well, but we still have to remember that there's a common sense approach when 16K was basically clearly complied with, and cites the 12th District Britannia case that the state had cited earlier, cites earlier in the brief, where testimony of an officer was given to defense. It wasn't an official expert report, but it was the officer's testimony in a prior case and a PowerPoint.
Just over 2 minutes left.
The last assignment of error, Judge, is the state's view is that none of this evidence was 404B other acts evidence. It wasn't objected to in that way. And I think the brief sets out sufficiently why the state does not believe that any of these instances were 404B evidence. And what it ultimately to be considered is looking at, without testimony from the caseworker from the Children's Services Agency, the impression that it could give a trier of fact is that this Children's Services Agency is going in concerned about this child over what appear to be, remember, they didn't know about the skull fracture at that point. So they're coming in concerned about what looked like overall minor injuries, not very significant injuries to the eye and I believe the arm. There was a healing injury there. And the state's presentation is, they're going to look at this child based on these injuries. And what it really does, the caseworker's testimony shows that the big, what could be portrayed as the big bad state agency, local government agency, had reasons to react the way it did, that this wasn't an over-the-top reaction toward the injuries sustained by this young child, 7 months old, but that the state had reasons, or this agency actually, had reasons for being concerned for this child's safety. And the background involving Ms. Heller was important to establishing the context for that concern and to providing a full version of events, the full story to the trier of fact. Therefore, the state asks that you affirm these convictions. Thank you.
Thank you. Counsel, you'll have 2 minutes and 8 seconds for rebuttal.
Thank you, Your Honor. Let me please the court. Responding to the state's assertion about the delayed testimony of the doctor. This doctor opined that it was inflicted in an accident. Part of the basis for that was that she talked about she didn't get a history meaning an explanation for the injury. The state did not present. Notice this assignment of error is on that opinion. It's not like the rest of her testimony where she talks about the bruise, the scratch, that there wasn't any other fractures. This is on her opining that it's non-accidental, it was inflicted. Why does the state in that same breath is then turning around and saying, hey, she went to Miami, Case Western, Yale, has worked for the Cleveland Clinic. She talks about her research and studies that she's done, testifies that her testimony will be done to a reasonable degree of medical certainty. This isn't just her actual observations, her actual treatment. She's opining that that fracture was inflicted and non-accidental. That is where that opinion comes in. And when it comes to address the state, when they were discussing was there evidentiary motions, there was a motion to compel file, and there was also a motion in Windy that was done shortly before trial, actually right as board year was starting. And then going to the 404. I said in the brief there's a 9th District case where this court cited that 404B evidence is that not brought to show that the person's the type of person that committed a crime, but that they were the person that committed a crime. All of that stuff that the social worker testified to, that the child, other kids were taken away, baby was born with marijuana, threatened to blow them up, all of that. That is stuff that she did that when you have 12 jurors sitting in a box, makes her look like horrible. All of them were objected to. This isn't a plain error case. This is an issue where every single time defense objects. The way this court operated, a lot of times they didn't allow a basis for those objections. Some for irrelevancy. That still goes into 404B evidence because it's all bad acts that they're claiming the defendant did. There was no 404B.
And counsel, you have used your time.
Thank you, Your Honor.
Thank you both for being present this morning and for your arguments. We'll take the matter under advisement and issue a decision in due course. Clerk of courts will mail each of you a copy of the decision on the day it's released, and the opinions are posted on the Supreme Court of Ohio's website. Thank you, counsel, again.
Thank you very much.